Lady, may I next show you El Ghazuli Daff and the Commissioner of Police at Divider 2 of the authorities. This was a case brought against the Crown Prosecution Service and the police, memory stick 287, in relation to the alleged negligent prosecution of the claimants for offences of rape in one case and terrorism offences in the other. And the appeals concerned the liability of the CPS, but the approach taken by the court reads across to the police, not least because that approach was itself taken from the Hill line of authority, or by analogy with Hill. At MS 298, Lord Justice...
I don't think that can be correct.
I think it can.
298. Oh, that's all right. Yes, that is. It was the first one that wasn't. Thank you.
Sorry, first one should have been 287.
Yeah.
I'm so sorry, I probably misspoke. At MS 298, Lord Justice Steyn, between letters D and E, in the context of an analysis of the impact of the Crown Prosecution Service's role, said the CPS acts for the public as a whole. It acts in the public interest. Over the page at 299, letter E, as I said, he regarded the Hill analogy as instructive. And then over at 301, MS 301, I'd invite the court's attention to the whole of the passage between letters C and E. I won't read it all out, but what he there says is that whilst it's always tempting to yield to an argument based on the protection of civil liberties, I've come to the conclusion that the interests of the whole community are better served by not imposing a duty of care on the CPS. In my view, such a duty would tend to have an inhibiting effect on the discharge by the CPS of its central function of prosecuting crime. And he then sets out some of the public policy consequences, all of which are driven by that fundamental point. The next case, please, at Divider 3, MS 306, is the decision of the House of Lords in Brooks and Commissioner of Police. As the court will know, the claimant in that case was the friend of Stephen Lawrence, who had been murdered by a racist gang. He, Mr. Brooks, was the principal eyewitness, and he said that he was injured by the police because of the way in which they dealt with him as a victim and a victim of and a witness to a very serious criminal offence. Each member of the appellate committee held that the claim should be struck out, and I'll just show you some passages. At memory strict 309, Lord Bingham, at letter A, said that the duties pleaded could not even arguably be imposed on police officers charged in the public interest with the investigation of a very serious crime and the apprehension of those responsible. And then at letter C, he said that these are not duties which could be imposed on police officers without potentially undermining the officers' performance of their functions, effective performance of which serves an important public interest. Same page, Lord Nichols at paragraph 5, at the end of that paragraph, observed these duties would cut across the freedom of action the police ought to have when investigating serious crime. Lord Steyn, of course, gave the most substantive speech, and at paragraph 30, memory stick 320, at letter G, he said that the prime function of the police is the preservation of the Queen's peace. The police must concentrate on preventing the commission of crime, protecting life and property, apprehending criminals and preserving evidence. A retreat from the principle in Hill would have detrimental effects for law enforcement. And then over the page at MS 321, Lord Steyn addressed a distinction that counsel for Mr. Brooks sought to draw between the facts of his client's case and the facts of Hill. And what Lord Steyn said, and this is a passage we do put particular reliance on, and it's picked up in Michael as we see. It's picked up in Smith as we'll see, and then Michael. Lord Steyn says at paragraph 32, while not challenging the decision in Hill, counsel submitted that it can be distinguished. The only suggested distinction ultimately pursued was that in Hill's case, the police negligence was the indirect cause of the murder, whereas in the present case, they directly caused harm. That hardly does justice to the essential reasoning in Hill's case. In any event, Calverley and El Ghazuli and Kumar were cases of alleged positive, I stress positive, and direct negligence by the police. The distinction is unmeritorious. And that observation we submit correctly recognises that the principles that underpin Hill are of general, not universal, but general application. Those principles don't depend on factual questions as to causation or distinctions between acts and omissions, or direct causation or indirect causation. Nothing in Hill or Brooks or any of the other authorities, I'll come to Michael of course, but nothing in the authorities we submit supports such a distinction. The rationale that runs through the authorities shows that the principles depend on the function that is being undertaken, and in particular that it's a function for the benefit of the public, rather than the manner in which, within the scope of that function, one properly characterises the police's conduct, whether as an act or omission, for example. And we therefore respectfully say that Lady Justice Hallett, in our case, was absolutely right at paragraph 27 of the Court of Appeal judgment, memory stick 145, to say that the distinction that the appellant was seeking to draw was, as she put it, demolished in resounding terms by this passage of Lord Steyn's judgment. My Lady, my Lords, the next case is Smith at Divider 4, MS 324. This was a domestic violence case, and the claimant had reported to the police a series of threats from his partner, and the police had effectively given him the runaround, hadn't properly investigated them. You get the facts most helpfully from the speech of Lord Bingham at memory stick 353, paragraphs 20 through to 27. Eventually, the claimant was the victim of a very serious assault, leading to very serious injury at his partner's hands, and he brought a claim against the police in negligence. Again, it was struck out applying the Hill rule, and may I just show you a passage from the speech of Lord Hope, memory stick 371, paragraph 74. Having in the previous paragraph picked up on the passage from Lord Steyn's speech in Brooks that I've already shown the court, Lord Hope at 74 says, between letters B and C, that it's clear from Lord Steyn's opinion, read as a whole, that he was laying down a principle of public policy that was to be applied generally, and that's why I've consistently used that word. He then referred to the passage in El Ghazuli that I've shown the court, and then at paragraph 75, same page, he says the phrase, the interests of the whole community, was echoed in the last sentence of the passage which I've quoted from Lord Steyn's opinion in Brooks. And then 2 or 3 lines further down at letter F, he says the point that he was making in Brooks in support of the core principle in Hill was that the principle had been enunciated in the interests of the whole community. Replacing it with a legal principle which focuses on the facts of each case would amount, in Lord Steyn's words, to a retreat from the core principle. And then at letters G to H, the greater public good outweighs any individual hardship. A principle of public policy that applies generally may operate harshly in some cases when they're judged by ordinary delictual principles. These are indeed the cases where, as Lord Steyne put it, the interests of the wider community must prevail over those of the individual. Then please Lord Carswell at memory stick 378, paragraph 106, to similar effect, letter G, one must acknowledge at once that the price of the certainty of the rule and the freedom from liability afforded to police officers is that some citizens who have very good reason to complain of the police handling of matters affecting them will not have a remedy in negligence. One has to face this and decide whether in the wider public interest the law should allow that. I agree with Lord Hope that in the interest of the wider community it is necessary that it should do so for the better performance of police work. And then, my lady, over the page, paragraph 108, between letters D to E, very similar observations, for example, to those we saw from Lord Nichols in the Brooks case. The factor of paramount importance is to give the police sufficient freedom to exercise their judgment in pursuit of their objects in work in the public interest, without being trammelled by the need to devote excessive time and attention to complaints or being constantly under the shadow of litigation. So that's Smith. My lady, I'll skip over the next case. The next case at Divider 5 is Desmond and Chief Constable of Nottinghamshire Police. It's a very different type of case, still within the police context, but it is a case of direct police action causing injury, in that in this case the police had negligently completed a criminal record certificate. This court is very familiar with that process, to include incorrect information resulting in loss and injury to the claimant. And exactly the same principles were applied. And without going to it now, could I just invite the court's attention, please, to paragraph 31 at memory stick 400 in the judgment of Sir Anthony May, giving the judgment of the court that also comprised Lord Justices Toulson and Leveson. So that's Desmond. And then I come now with that rather long run-up to the decision of this court in Michael at Divider 6, memory stick 408. And this, of course, was the truly dreadful case where the claimant's daughter had made an emergency 999 call seeking the police's assistance because of an immediate threat from her ex-partner. There was a delay in the police response, and by the time they arrived, she had been murdered. Lord Toulson gave the leading judgment, with whom Lord Newburger and my lords Lord Mance, Lord Reed and Lord Hodge agreed, and my lady and Lord Kerr each, of course, gave dissenting judgments. And Lord Toulson, in the majority judgment, goes through the authorities in some detail. Memory stick 427, paragraph 49. Having referred to Lord Steyne's judgment in Brooks, so memory stick 427, paragraph 49, Lord Toulson said that by endorsing the principle in Hill in the terms in which he did, Lord Steyne confirmed that the functions of the police which he identified were public law duties and did not give rise to private law duties of care, whether to victims or witnesses or suspects. And then at 51, same page, memory stick 427, he said, and again this refers back to a passage I've shown you, Lord Steyne in Brooks referred to an argument that the Hill case should be distinguished on the basis that in that case the police negligence was the indirect cause of the murder, whereas in the Brooks case the behaviour of the police was a direct cause of harm. Lord Steyne observed that this hardly did justice to the essential reasoning, and it was an unmeritorious distinction. So absolutely follows through the logic of the previous authorities. The majority do not say anywhere in this judgment that all of that needs to be reappraised in any way, or that it was at odds with fundamental principle. When he came to consider whether a duty was owed to Joanna Michael, the maker of the 999 call, he started from a broader perspective for reasons which are, my respectful submission, very clearly explained in my lady's judgment, which I'll come to in a moment. But he also went through, after that introduction, he did also go through the cases that deal with the position of public authorities outside the police context, particularly Stoven and Wise and others. And at memory stick 440, can I invite the court's attention to paragraphs 114 and 115, and indeed paragraphs 120 and 121 on the following page. I won't read all of those out, but what he says is that just because you set up a protective system, and whichever public body it is, whether it's the police or another public body, through organisational defects or fault on the part of an individual, the public at large should bear the additional burden of compensating a victim for harm caused. It doesn't follow that the public at large should compensate the victim for the additional burden of compensating a victim for harm caused by the actions of a third party for whose behaviour the state is not responsible. And as he explains, that simply accords with fundamental principle. And at 120 and 121, he starts to explain, or he explains the difficulties that would arise if you started to impose duties for the benefit of particular individuals, not others. So, and this reads across in our case, in my submission, to a duty to the appellant, but not to the person to be arrested, or not to a person who was in the next street if the offender travelled that far. Where does one draw the line is the underlying point. And at 121, although Lord Toulson, speaking for the majority, was, like Lord Steyn in Brooks, prepared to observe that one could be critical of some of the observations in Hill itself, and the fact that one could be a little more sceptical than some of the speeches in Hill suggest, nothing in these paragraphs in our submission doubts the correctness of the decision in Hill, or indeed any of the later authorities. And indeed, as he points out, the one consequence of which one can be sure is that imposing liability would lead to the costs of dealing with the claims, and that would have to come from the police budget with a corresponding reduction of spending on other public services, or from an increased burden on the public, or from a combination of the two. My lady, the appellant focuses considerable part of the argument on the observation of Lord Toulson at the start of this section of his judgment at paragraph 97. That's memory stick 436. And the observation to the effect that the common law does not generally impose liability for pure omissions. That observation, we submit with great respect, is obviously correct. The common law doesn't do that. But it doesn't follow that the converse applies, and it doesn't follow that the rule in Hill is based on that common law principle. On analysis, for all the reasons I've given, and when one looks at the reasoning in each of the authorities, the rule in Hill is indeed of general application and is not limited in the way in which the appellant asserts. There is, we submit, no indication that Lord Toulson or any other member of the majority considered that the rule in Hill should be confined to cases of pure omissions. This observation at paragraph 97 was not made in the context of a discussion of the Hill rule, nor was it made in the context of a discussion about the role of the police. It was, as the following lines and paragraphs make clear, in the context of the discrete line of authority established in cases that have nothing to do with the police, that there's no general duty to protect a person from harm caused by a third party. Now, of course, although those authorities have nothing to do with the police, they apply equally to the police, and the police can therefore, the courts must therefore apply those principles in a police case, which provides a second reason, as I'll come to, why there is no duty. But it has nothing to do, we submit, with the scope of the Hill rule. It's taken directly from Lord Goff's speech in Smith and Littlewoods. I'm not going to go there now, but for my lady and my lord's notes, it's MS 1473, volume 4, tab 37 of the authorities. And Lord Goff was there making a general observation about the common law, not linking it in any way to duties that arise in the context of the police's investigation of crime. My lady, as I said a moment ago, we submit that your ladyship's judgment shows the reason why Lord Toulson and the majority were able to look to the rule in Smith and Littlewoods. We have that at memory stick 459, at paragraph 189, right at the start of your judgment. And what your ladyship there says is that there are said to be two objections to imposing a duty. The first is the Hill rule, the core principle recognised in Hill. That's what I've been submitting about thus far. And as your ladyship says, we respectfully agree, the principle is no longer regarded as an immunity, but as a situation which, for policy reasons, no duty of care is imposed by the law. We entirely agree. The second, so completely separate point, is the general principle in the law of negligence referred to by in the academic papers that Mr. Bowen has referenced as the omissions principle. And then my lady sets that out. And then at 190, you say the second objection is the more serious, for there would be little point in considering the strength and validity of the policy reasons which led to Hill and to apply it if the claim were bound to fail anyway under the ordinary principles of the law of negligence. And so we respectfully submit that it is incorrect to read from paragraph 97 a very significant change and challenge to the very long-standing and established principles that have been worked through in the authorities I've shown you in this bundle, Bundle 1, and in many, many other cases.
But Mr. Johnson, you have to see those observations, don't you, in the context of a long hearing in which a full frontal assault has been made on Hill.
Yes.
So it's not surprising that what the majority did was say, well, for ordinary common law reasons, this claim fails in any event. And so we're not going to, in a sense, enter into that debate.
My lady, I entirely agree.
Because there was a very, as Lord Toulson accepted, the criticisms of the policy reasons, which had been kind of intuited by the House of Lords in Hill, had considerable force, as he said.
My lady, I agree. I don't seek to take issue with that. But the fact, I entirely agree with you.
And it was a seven-judge court, so that the court could have departed.
It could have done, but it didn't.
But it didn't need to.
It didn't need to. And my point is that it didn't. And it left undisturbed that line of authority. I appreciate, my lady, of course I appreciate that there are very significant arguments to be had about the Hill line. They're not being advanced here. My learned friend has expressly disavowed any intention to persuade the court to depart from any previous decision of this court or the House of Lords. They were advanced, they were spiritedly advanced, if that's a word, by the interveners and by the appellant in Hill. As my lady says...
Mr Johnson, I've forgotten whether you were in, Michael.
As a minor role, as Lord Panix Jr., but yes.
I didn't think that you were on your feet. No.
Mr. Baron was.
He was, yes.
Yes, but there,
not on the same side.
But no, there it is. So our fundamental submission is that it's not the case. What comes out of this, and I entirely understand the explanation for why Lord Toulson was able to approach it as he did. Entirely understand that. But it is simply not the case that the Hill rule is based on the omissions principle. They are two quite separate things, either or both of which might operate to bar the imposition of a duty. My lady, before I move from Michael, I've acknowledged that both your ladyship and Lord Kerr dissented, but our respectful submission is that on the facts of a case like ours, the approach adopted by Lord Kerr in Michael and with which my lady agreed would not assist the appellant here. And for that proposition, could I show you...
dissenting judgments are dissenting judgments there. Written sand.
Well, I won't... It's a little harsh because sometimes they're picked up later on. But my lady, I take the point, and I won't go to it. Just for your note, it's paragraph 170 at Memory Stick 455, where Lord Kerr made it clear that although he would narrowly confine a duty, effectively on a variation of Lord Bingham's dissenting speech in Smith, he wouldn't extend it to, for example, a bystander. But I do take my lady's point. Can I also just briefly mention the driving cases that I think Lord Reid made reference to this morning? I, of course, accept that it is well established that drivers of motor vehicles owe one another a common law duty of care.
Not only one another.
Well, they
owe it to pedestrians, cyclists,
oh, yes.
and
yes.
Other people whom they may injure by carelessness.
My lady, I agree. I mean, I'm thinking of a paradigm case of a road traffic collision between two vehicles, but I entirely agree. But that is an established category. And whether or not and this may ultimately be semantics, whether or not you say that the police, when they're driving a car, are exercising their function of detecting and preventing crime or exercising a function of driving a car, the fact is that this is an established category that's never been challenged and has been applied to the emergency services, albeit with the qualifications about the scope of the criminal law, as much as to anyone else. But even there, it's our submission that it wouldn't greatly assist the appellant here, because the duty of a car driver or whatever it is to take reasonable care so as to avoid directly injuring any other user of the road, whether it's pedestrian, cyclist or driver. What you don't have is a duty that would extend to the conduct of another driver. So in a police context, for example, if the police are pursuing somebody who has failed to stop and they collide with a pedestrian or a cyclist, then they owe a duty of care and there'll be questions of breach and causation and so on. But if the driver they are pursuing so negligently manoeuvres their vehicle that they collide with a pedestrian or cyclist, the police aren't under any liability.
Well, that's a separate point.
But that's in my submission the analogue with our case.
Well, yes. It strikes me the issue of whether there's a duty of care is different from the question whether, on particular facts, a breach of that duty was the cause of the injury.
Well, I agree. My submission, those are separate. Those are separate questions. But you do need to look both at the firstly, the existence of a duty, secondly, the scope of a duty, and thirdly, questions of causation. I respectfully agree. But here, that there is that further step removed.
I mean, what is the distinction as regards the police's conduct? It's called operational by Lord Hope, the liability during the course of driving, I think. Is it because driving is an everyday function, we're expected to be able to make the necessary adjustments if we're doing it in a rather crisis situation, whereas arresting is not an everyday activity, and how is one to distinguish? I mean, you partly helped us by saying, well, we're talking about different victims here, or at least different causation of the victim's injuries.
My Lord, my submission is, my primary submission on this is that driving is it's an established category. Exactly.
It's something one does every day.
Exactly.
So one's expected to be able to adapt it appropriately in crisis situations.
Well, the law has recognised that there is a special relationship between drivers and anyone who might be directly harmed by their driving. That's an established category, and it applies to all of us, and it applies to police drivers and ambulance drivers and fire engine drivers as well. They're entitled to to breach certain regulations about going through red lights and speeding and so on, but they still owe a duty to exercise reasonable care. That is quite different, and it's been accommodated in all of the authorities. It's quite different from the police exercising their investigative and crime prevention functions, even though you might be driving to a victim or you might be driving after a suspect. That was our second submission, the scope of Hill and whether Michael brought about a sea change. If we're right that the Hill rule is not based on the omissions principle and that they are two quite separate things, then it's not necessary to assess which side of the omissions line this case falls. That's because the distinction has no application, and the case fails in our respectful submission on the basis of the trite application of the Hill rule.
Are you going to come to Rigby later on?
Am I going to come
to Rigby later on? Since you've done the driving cases, I just wondered whether it would be a convenient point to...
I was going to come to Rigby later on. Let me deal with it.
Do it then.
Well, my lord, let me deal with it now, because it's another similar question. Can I start with the firearms cases? There's a series of cases that my learned friend relies on. Attorney General and Hartwell, Divider 9, Memory Stick 528. That's the particular passage I would rely on at paragraph 25. The Ashley case, which was a police shooting case where there was a concession, and others as well. My lord, in a firearms case, and Rigby is not far removed from this, in a firearms case, there would ordinarily be an action in assault, and a claim in negligence would not therefore necessarily need to be considered. And if it's territory that's covered by an assault claim, it wouldn't be necessary to stretch well-established principles to seek to accommodate a negligence claim. So depending on the facts, you don't even need to consider negligence. But leaving aside the question of an assault claim, the viability of a negligence claim where the police are using very high levels of force, such as discharging firearms or firing CS canisters into a building where it's known that that's likely to result in a fire. Those cases are likely to be very highly fact sensitive. And the reason for that is that firearms and certain other types of equipment and weaponry give rise to such a significant and obvious risk of fatal or very serious damage that an application of the Caparo test may yield a different result. I've said that Hill is not a universal rule. It's based on Caparo, and it's well established that there are circumstances in which applying Caparo gives you a different outcome, even in the police context.
I think Hill's really a hangover from Anne's, isn't it? That Lord Keith looks first of all at questions of proximity and so forth, and having found there was no proximity, he could have stopped there, but he goes on to deal with stage 2 of the Anne's analysis, which is the policy reasons for excluding liability.
My Lord, that's absolutely right, but of course it's continued to be applied. Hill, of course, predated Caparo, but it's continued to be applied. But the Caparo test isn't a statute or algorithm that where you look independently at the three different stages. The component parts aren't hermetically sealed. Although the first stage of the test is whether there's a foreseeable risk of injury, that doesn't necessarily mean you have a binary answer, yes or no. Where the injury is not just foreseeable, but as in a firearms case or a case like Rigby, obvious and immediate and of a very serious level of harm, including loss of life, then that may well inform questions of proximity and public policy. And where the mechanism by which injury might be caused is not the actions of a third party. I mean, I've said that Hill applies generally, but I do accept that where the mechanism by which injury might be caused is not the actions of a third party, but the direct application of a very high level of force by the police, then that too might inform questions of proximity and public policy. And so, if I could ask the court to turn up Attorney General and Hartwell, which is in divider 2, memory stick 521. This was a firearms case. It was a case where the chief officer had negligently allowed an officer access to a firearm who had then committed an atrocity. And the submissions I've made in my submission are supported by what is said at memory stick 528, Lord Nichols giving the judgment of the Privy Council. Between...
Correct, it wasn't technically a judgment.
I'm so sorry. The opinion.
Never mind.
I'm so sorry, my lady. Between letters B and E.
Stated to be.
I was going to say, they're always headed judgment.
But it's the British Virgin Islands. Anyway.
It's advice.
If that's the biggest mistake I make, I'll live with it. My lady,
humble advice.
528.
yes, 528.
Paragraph 25.
Paragraph 25. If I can pick it up between letters B and C. In some circumstances, the need for a high degree of likelihood of harm mentioned by Lord Reid may be an appropriate limiting factor in cases involving deliberate wrongful human actions. In other cases, foresight of a lesser risk of harm flowing from a third party's intervention will suffice to give rise to a duty of care. The law of negligence is not an area where fixed absolutes of universal application are appropriate. In each case, the governing consideration is the underlying principle. The underlying principle is that reasonable foreseeability as an ingredient is a broad and flexible objective standard, which is responsive to the infinitely variable circumstances of different cases. The nature and gravity of the damage that is foreseeable, the likelihood of its occurrence, and the ease or difficulty of eliminating the risk are all matters to be taken into account in the round when deciding whether as a matter of legal policy a duty of care is owed.
If I didn't know that was written by Lord Nichols, I would nevertheless have guessed
Well,
that
it's
it was
classic.
written by Lord Nichols. It sums up so many of his general approaches to legal questions.
But so I'm not arguing for a rigid rule of universal application. I accept that quite apart from the acknowledged exceptions, the well-established exceptions such as voluntary assumption of responsibility, and there's others, that there will be cases at the margins, potentially involving very serious high risks, direct use of firearms and the like, where a different result comes out of the application of the Capare test. My lady, I'm not going to trouble the court with comparative law, but on this issue, could I just give you a reference to the approach that's been taken in New Zealand, where they've looked at applying Hill in the firearms context and these sorts of cases. The cases are brought together in an article at Divider 71, and in particular, two cases, one that's referred to at MS 261, which is Zalusaki, and one at Memory Stick 2626, which is Klein. And the court will see there that the New Zealand courts reached different decisions. And in the first case in time, a duty of care was imposed. In the second case in time, it wasn't, in firearms cases. But it shows in my submission that there is that degree of flexibility. Now, I can't say why Rigby was decided as it was, because the judge adopted the brilliant strategy of not explaining, well, it's not his fault, there was no argument on the question of public policy.
Never raised at all.
Exactly. So I'm not saying this was the reason for the outcome. Well, the reason for the outcome, I suppose, was that it was never raised at all. I'm not saying that the reasoning must have been analogous to Attorney General and Hartwell, but I do accept that I accept that no court in the authorities we've looked at has doubted the correctness of Rigby. My submission is that it does sit with the fundamental underlying principles that I've sought to outline.
In determining what is the core principle in Hill, do I take it from what you're saying just now that you're broadly in agreement with what Sir Anthony May said in Desmond at paragraph 31, where he treated it as a matter of, in the absence of special circumstances, and they're not generally being a duty of care. That is really your position, is it?
My lord, exactly that. Exactly that. And I've outlined the sorts of cases where you might have the special circumstances using a very high level of force. My lady, I was just moving on to my third submission, which I'll deal with very briefly, which is the point about whether or not this case is correctly categorised as an omission case or a positive act case. It's an alternative submission because the court understands my primary stance on the Hill line of authority. My learned friend says that the difference between positive acts and negative omissions ultimately may be largely a matter of semantics. And in some ways, I respectfully agree with him. But if that's the case, it would be surprising if it has the very dramatic legal consequences for which he contends. In our submission, what one needs to drill down into is what was the direct cause of the harm to the appellant, and whether that was due directly to an act of the police or something which, so far as the police were concerned, is properly categorised as a failing or omission. And on the findings of fact, both of the recorder and the Court of Appeal, the direct cause of harm was the unlawful conduct of Mr. Williams in resisting arrest. So as Lady Justice Hallett put it, at paragraph 53 of the Court of Appeal judgment, Memory Stick 151, the claim is for harm that was indirectly caused to the appellant by the police's failure to prevent him from causing harm to her. Now, of course, I accept that Mr. Williams acted as he did in response to the police officers who were trying to arrest him. And that provided the context or the occasion or the circumstances in which Mr. Williams caused injury to the appellant. But the police decision to arrest, which is not, that's the only positive step, and that's not a step that's criticised either by the pleadings or by any of the judges in the courts below, the police decision to arrest was not the direct cause of the injury. The direct cause was the conduct of Mr. Williams. What is complained about is what's said to be the failure of the police to plan appropriately or to delay the arrest, carry it out at another occasion, or to ensure that the second pair of officers were closer so that all four officers could have seized the appellant at the same time. That would lead on to all sorts of questions of causation. But the underlying basis on what the claim, on which the claim is brought is failures or omissions rather than positive steps, because everybody agrees, as I understand it, that Mr. Williams was a man who needed to be arrested. So even if the Hill rule were limited to omissions in the way that's been suggested, that would not avail the claimant here. My lady, that's our third submission.
Yeah, the case against you obviously is that involves salami slicing. What the police were doing was arresting a fit young man in the possession of incriminating drugs who would be expected to react in a way that he did.
Well, my lord, I agree that it's reasonably foreseeable that he would react in the way he did, and it was foreseen. That's why they drew up the plan they did. I'm not seeking artificially to salami slice. What I'm seeking to do, and this is in my submission consistent with principle, is to identify the cause of harm to the claimant and to determine whether that cause, whether what the police did or failed to do that resulted in that, directly resulted in that, is an act or omission. Now, one could take a different case where what was being said is that the police were directly taking some step that they shouldn't have taken. Take, for example, Rigby, where they fire in the CS canisters into the building where there's no immediate need to do so, and they could have waited for firefighting equipment to be on standby. In that sort of case, I respectfully agree that you could semantically or by salami slicing say that it's an omissions case because it's a failure to make sure that the fire brigade are on standby. But one has to look at it realistically and ask oneself, what is the real cause of the claimant's injury? And in that case, the real cause was the police firing in the CS canisters. That directly resulted in the fire. By contrast, in our case, the police were doing what it was their public duty to do, namely to arrest the appellant. I'm so sorry, the offender. And he reacted, albeit in a manner that was foreseeable, nevertheless in a way that was unlawful, and meant that he bore the substantive responsibility.
The trouble is that there isn't such a thing as the real cause in the abstract. As Lord Hoffman has pointed out repeatedly, cause is always contextual. If you were asking in an action against Mr. Williams, who caused this, it would be a hopeless suggestion by Mr. Williams that the police caused it. But in an action against the police, you're naturally focusing on what the police might have done differently or what they did. And coming to your point about omissions, I mean, the reality is that the criticism against you is that they launched an inadequately prepared and structured arrest. So it's put as a positive thing. They shouldn't have acted, shouldn't have gone forward in that way at that time as they did.
Well, I take the point. There is in my submission a risk, and I'm guilty of it in the way I've put my submissions, in conflating questions of causation with questions of duty and categorising whether...
Well, they unfortunately are a bit mixed up.
Well, they are.
If you're asking whether someone is responsible, then every little fault can become much more significant than it really is in the overall scheme of things.
Yeah. Yes, and I mean, if I could build on that point, when I was talking about every little fault, in the way in which the Master of the Rolls dealt with the Marshall case was to draw a distinction between negligence and simply an error of judgment in a situation where a snap judgment has to be made without the time to sit and think about how exactly matters might best be done.
My lord, that's exactly right. And you have another example of that. I'm not going to go to it, but can I just give it to you for your reference? You have another example of that in a relatively recent case at Bundle 9, Supplementary Memory Stick, page 203. It's a claim brought on behalf of the estate of David Rathband against the Chief Constable of Northumbria, arising out of the activities of Raoul Moat, who committed an atrocity in Northumbria. And Mr. Justice Males, at paragraph 107, Memory Stick 228, seeks to extract the legal principles. And he makes the exact point my lord's just made at 107 paragraph 3, that a duty will be excluded or is more likely to be excluded in cases involving operational decisions concerning the investigation or prevention of crime which are taken under pressure, whether of time or due to other circumstances. That was a case where a police officer had been stationed on a particular roundabout. It became known very shortly before he was shot that he was at risk from the offender. He wasn't given a warning. He was allowed to remain on that station. He was shot. He tragically lost his sight and subsequently took his own life. So a very tragic case. But it's that same point about making decisions in compressed periods of time.
But that consideration there went, did it, to the existence of the duty of care rather than to the measure of it?
Yes.
Or the content of it?
Yes, because the court found that there was no duty. The court found in the alternative that there was no breach, but found that there was no duty.
It's the same point as the Lord Nichols' point.
Yes.
Yeah.
Well, you might come to my fourth submission. And that's this. Even if we're completely wrong about Hill, there is, we say, a second and even more fundamental reason why the claim fails. That's the omissions principle, taken from Lord Gough's speech in Smith and Littlewood's Memory Stick 1473, and then picked up and applied by Lord Toulson for the majority in Michael, at paragraph 97 of Michael, that the court's very familiar with now, Memory Stick 436. Namely, that English law does not, as a general rule, impose liability on a defendant for injury or damage to the personal property of a claimant caused by the conduct of a third party. And that is exactly, we submit, our case. I've already made submissions about the concurrent findings of the first instance judge and all three members of the Court of Appeal. They are, firstly, from the first instance judge, Memory Stick 139, paragraph 4, and from the Court of Appeal, Memory Stick 160, paragraph 20. And that means the fact that what we are here concerned with is, it's another way, I suppose, of putting the point I was making a moment ago. What we are here concerned with is an application of the omissions principle, that because the damage to the appellant was directly caused by the conduct of Mr. Williams, we are within the scope of that principle. Now, of course, I accept that there are exceptions to that principle. They're identified in Smith and Littlewood's itself, at the reference I've given, Memory Stick 1473. Memory Stick 1474, letters D to E, and two of them are identified in the speech of Lord Toulson in Michael. The one on which the appellant particularly alights is the exception where there's a special relationship between the defendant and the third party, the offender, by virtue of which the defendant is responsible for controlling the actions of the third party. And the classic example, of course, is the decision in Home Office and Dorset Yacht. In that case, there was a relationship between the Home Office, or the governor, and the Borstal boys, because the boys were in the governor's custody. He was able completely to control, within obviously legal limits, where they were, what they did, and the conditions under which they were confined. And he owed a statutory duty to keep them secure and to prevent them from escaping. That was because of the pre-existing close relationship that the law was able to impose as an exception to the omissions principle. So it was because of that pre-existing close relationship that the law was able to impose as an exception to the omissions principle, that a corresponding common law duty arose to prevent them from escaping. And there was proximity with the claimants because of the particular facts of that case. But in our case, Mr. Williams was not at any stage in the custody of the police officers. Of course, they had a power to arrest, and I've shown the court that power in section 24 of the 1984 Act. But it's not an exception that arises where you have a power to control somebody. It's an exception that arises where you are, in fact, exercising de facto control. And at the time of the conduct about which complaint is made in this case, the failure to plan the arrest, the failure to have the other two officers on closer standby, there was absolutely no ability on the part of the police to control Mr. Williams's conduct. And we therefore say that this is not a case that comes within that exception. The second exception on which my learned friend relies is the exception that applies where a defendant has, by his conduct, created a very particular risk where it's eminently foreseeable or likely that a third party will exploit that risk so as to cause injury to a claimant. The classic examples being somebody who's left one of the cases, a cart and a horse untethered, where it's likely that the horse could be caused by a third party to run amok and cause injury, or leaving noxious chemicals unsecured in circumstances where it's likely that vandals will exploit that. In our submission, we don't come anywhere close to that sort of case. Here, the police hadn't left a dangerous situation which could then be exploited by a third party. By arresting Mr. Williams, of course, there was a risk that he would react. By arresting anybody, or in the general scheme of things, by arresting young, fit men, there's a risk they will react. Equally, by not arresting somebody who's committing criminal offences, there's a risk that they will go on to commit further offences. It's not the police that create a danger that's then exploited. The correct way to categorise this in our submission is that the police are discharging their public duty to perform an arrest. And it's not that Mr. Williams then exploits that. He's not exploiting it for his own purposes. He's seeking to evade it. And we therefore say that, likewise, that exception here doesn't apply. Lady, that's our fourth submission. Our fifth submission was that the appellant is, we respectfully say, incorrect in the submission that there's a general duty of care not to cause foreseeable physical injury to anybody else. For the reasons I've given, we submit that there's no duty of care here, both because of the Hill rule and also because of the omissions rule. The appellant's response is that she comes within an established category where a duty is owed. And in particular, she says, this is appellant's case at paragraph 6, memory stick 57. In particular, she says, she comes within the category established that a duty of care, there is a duty of care not to cause any physical injury, which is a foreseeable consequence of one's positive action. My lady, my lords, we of course accept that there are many cases where a duty of care will be owed in such circumstances. In most conventional personal injury claims, one doesn't get to asking about questions of proximity and questions of public policy because, as I think it was my Lord Mance said earlier, it's axiomatic. One doesn't need to worry about it. But that doesn't mean that those conditions aren't still there in the background to be applied in the relatively unusual cases where they get traction. And so as a principle, we say that the appellant's proposition is far too broadly stated. Reasonable foreseeability has never been enough in itself to give rise to a duty of care. Of course, it's enough where it's accompanied by a special relationship of proximity and where there are no countervailing public policy principles to engage third limb caparo. But it doesn't suffice by itself. And for that proposition, could I take the court right back to the start, so far as this type of case is concerned, the decision in Hill, Divider 1, memory stick 281, where Lord Keith said at letter B, it has been said almost too frequently to require repetition.
Sorry, what was the page reference?
I'm so sorry, memory stick 281.
Thank you.
It's been letter B, between letters B and C. It's been said almost too frequently to require repetition that foreseeability of likely harm is not itself a sufficient test of liability in negligence. And we therefore submit that the appellant's principle leaves out some important control mechanisms. There are numbers of cases.
I think he limited it to...
I'm so sorry, my lord.
I think he limited it to foreseeability of physical injury. Otherwise, you get into all the economic loss cases.
Yes. No, I agree that it was limited in that way. But in my estimation, even though, no, you're right. But even though it's too broad, and there are numbers of cases where, just in the police context, direct police action, which is, and I'm not going to go back over the acts and omissions debate, but direct police action has caused injury. See, for example, El Ghazouli Daf, memory stick 287, Brooks, memory stick 306, we've seen the facts of Brooks, Calverley, where disciplinary proceedings were brought and they caused injury, memory stick 533, and Kumar, another prosecution case, memory stick 912. If the appellant were correct, even limiting it to cases of physical injury, if the appellant were correct, it would have very profound consequences. There are many situations every day in which the police directly use force, knowing that it will harm or is likely to harm an individual. At one end of the scale, you have the simple act of applying handcuffs or laying on hands to carry out an arrest. And at the other end of the scale, and sadly this is not fanciful, you have an armed officer confronting a suspected suicide bomber and using lethal force. In all those types of cases, the police, of course, have to justify the force they use. The burden in a civil claim for assault would be on the police to justify the use of force, and if it's not justified, it amounts to an assault. But it would be absurd in our submission, it would be nonsensical if when the police are discharging their public duty to prevent crime by using direct force, whether it's applying handcuffs or at the other end of the scale, to say that they owe a duty of care to the person who is going to be harmed to avoid causing injury to them or to minimise that injury. They are protected, the appropriate tort through which they are protected is that of assault and battery, we submit, not negligence. Now, much of the weight of the appellant's submission on this...
I mean, does that go to... Is that the same question as whether they owe a duty of care to innocent third parties, though? I mean, if you take one of the recent tragic events in this capital, would there be a distinction potentially between police use of force against someone who they believe to be a perpetrator and their liability to someone who might be hurt by a ricochet or if they miss their target?
My Lord, the same principles apply in my submission. If they're hurt by a ricochet or they miss their target, the victim may have a claim in assault, and there may be questions of transferred malice and so on. But to say...
say no negligence.
I say no negligence. I mean, subject to what I've already said about Attorney General and Hartwell and the firearms cases, and it may be that it's not helpful to look at the very serious use of force, because, as I've said, then the Capari test may yield different results. But in routine policing, like our case, where you're not going to get into those extremities, in routine policing like our case, you have a remedy in assault, but for the Hill reasons and the omissions principle reasons, there's no liability, we say, in negligence. And the examples I was giving wasn't to seek to show that there's no duty of care generally. It was limited to contesting my learned friend's proposed principle that once you use direct force, once you take a direct act that causes foreseeable physical injury, you owe a duty of care. That, we say, cannot be right. My Lords, the authority on which, as I understand it, the appellant principally relies for this part of their case is the judgment of Lord Justice Hobhouse in Perrott and Collins, which you have in Bundle 4, Divider 33, at Memory Stick 1340. And the court's already been told about the facts of this case, and in my submission it's entirely unsurprising that on these sorts of facts a duty of care was owed. But it was suggested, as I understood it, that the argument focused on the same points of public policy. We're not sure that is correct. Could I show you, please, Memory Stick 1343 in the judgment of Lord Justice Hobhouse at letters B and C. Letter B, he says, no point has been taken on the question of reasonable foresight, accepted that there's reasonable foreseeability. And then similarly, although there were delegated statutory functions, no arguments such as the plaintiff. Similarly, this is at letter C, page 1343. Although there were delegated statutory functions, no argument has been raised that there is any overriding principle of public policy which protects the second or third defendants from liability. The focus then was on questions of proximity. So it's a case where the wider policy considerations that apply in cases such as Hill simply weren't engaged. But if that were not enough, could I show you page 1349, Memory Stick 1349, at letters D to G, or indeed over the page to 1350 letter A. I won't read the whole passage now, but what Lord Justice Hobhouse there recognises is that there are cases where, even though you have foreseeability of harm, that principles come into play which prevent a duty being imposed. Look at between letters F and G. Other cases have concerned the liability of some public institution or body for adverse consequences suffered by members of the public. There, questions arise whether what can be recognised as a general public duty owed to the community as a whole can be used to support an allegation of a duty owed to particular individuals. Contrast Dorset, Yacht and Hill and Chief Constable of West Yorkshire. Precisely our point. It doesn't, in our submission, do away with third limb caparo in all cases. All it recognises is that where you don't have arguments about policy, then reasonable foreseeability is sufficient if you have directly caused injury to the claimant, because that direct causation of physical injury itself provides the relationship of proximity to fulfill the second category. That's, in our submission, how one should properly construe those cases. Well, it was here that I was going to deal with Rigby, but I've made my submissions about that, and I've made my submissions about the driving cases and the other cases on which my learned friend relies. None of them in our submission throw doubt on the principle in Hill or its applicability to the facts of this case. My lady, that takes me then to my final submission, and that concerns the question of breach of duty, and it's dealt with in our case between paragraphs 60 and 72 at memory stick 128. And I didn't understand submissions to be advanced orally to the court this morning on breach of duty, so I'm responding to the written case, and indeed we responded to that written case in our written case, and I'll therefore be brief on this topic unless there's anything on which I can assist. My lady, I'm not going to rehearse the question that's canvassed in the statement of facts and issues about the scope of ground one of the appeal. That's entirely a matter for the court. If the court's view is that breach of duty is within the ambit of this appeal, then our submission is the Court of Appeal made very clear findings that the learned recorder was wrong on this issue. The appellant submitted in writing and did submit orally this morning that the Court of Appeal made no such finding. We respectfully submit that that is not sustainable when one looks at the content of the judgments of, on the one hand, Lady Justice Hallett, and on the other hand, Mr. Justice Arnold. And could I take the court then, please, to the Court of Appeal's judgment, which you have at memory stick, starting at memory stick 138 in the core volume. And the following passages amply show that the Court of Appeal did make findings that the learned recorder was wrong. Not just a question of doubting his findings, they made positive findings that he was incorrect. And these, of course, have been raised on a respondent's notice advanced by my learned friend, Mr. Scout. So firstly, at paragraph 52, please, on memory stick 151, the heading is on the previous page. The heading at the foot of page 150 is conclusions on the trial judge's findings. And the last sentence of that paragraph, Lady Justice Hallett says, the evidence did not justify finding the officers were under a duty to Mrs. Robinson, even disregarding the Hill principle, or that they were negligent. So the evidence did not justify a finding that they were negligent. That must mean breach of duty. That in itself is a clear finding, but then read down, please, to paragraph 59 and 61. Paragraph 59, I invite the court to read, I'm sure the court already has the whole of this, but the last sentence of 59, to my mind, my submission a clear finding by Lady Justice Hallett, to my mind, the evidence did not come close to justifying the recorder's criticisms about the handling of the police operation when one reads this in context. And then at paragraph 61, again, the last bit of this paragraph, where Lady Justice Hallett is responding to the delay in 3 seconds in the additional officers reaching the scene, that's hardly worthy of criticism in these circumstances, even if it was a mistake and a causative one, an issue that the recorder hadn't addressed, had completely left out causation. Mistakes are not necessarily negligent. And then in the judgment of, in the concurring judgment of Mr. Justice Arnold, could I show you paragraph 67? And really, my short answer, my short submission on submission 6 is paragraph 67 of Mr. Justice Arnold, because that just explains in my submission why the recorder went wrong. But you see there that in the first sentence, even if the police did owe a duty of care, the conduct of the arresting officers did not fall below the standard to be expected of reasonably competent police officers. Again, in my submission, a very clear finding that there was no breach of duty. And then further on in 67, 4 lines from the foot of page 153, in any event, I do not consider that his findings justified a conclusion of negligence. Those amount in our submission to clear findings that the recorder was wrong to find a breach of duty. There's suggestion in the printed case for the appellant that these are obiter findings. Well, of course I accept that the claim failed because there was no duty of care, and to that extent, in the technical sense, they're obiter, but that's not the point. The point is that they are clear findings that with which the appellant would need to grapple to get home on the question of breach of duty. The next question is whether the Court of Appeal were entitled to reach the conclusion it did to overturn the recorder on the question of breach, and we respectfully rely on the analysis of Lady Justice Hallett at paragraphs 59 to 61, and I've shown you extracts from that, and that of Mr. Justice Arnold at paragraph 67. They show why, in our submission, the court was plainly entitled to reach its own view. It's not a question of having to defer to fine assessments made by a first instance judge who's had the benefit of seeing witnesses as to which witness he believes and which he doesn't, or which witness is reliable and which is unreliable. The Court of Appeal had the CCTV. There was no dispute of fact in any event, no substantive dispute of fact. This court has the CCTV. Of course, I'm absolutely content for the members of this court if you think it would assist to look at the CCTV. You have the series of stills which tell their own story, and you see the timings on that. So you see in this, as we went through the stills this morning, that it's within 2 or 3 seconds that the second pair of officers arrive. And in our submission, the Court of Appeal were absolutely right to find that the judge is wrong. Nothing unusual or unconventional in the Court of Appeal taking that sort of approach, by which I mean overturning a first instance judge's assessment of whether there's been a breach of duty, where there's no real dispute about the underlying facts. It's just a question of assessing whether those underlying facts amount to a breach. And I give 2 examples. I'm not going to go there unless the court wishes me to, but could I give you as 2 examples the decision of Lord Justice Bean in McDonnell and Commissioner of Police. That's reported at 2015 EWCA Civ 573. It's at volume 3, authority 27, paragraphs 24 to 28, memory stick 986. As it happens, it's a case about an arrest of a drug dealer. The first instance judge found that the level of force used was unreasonable. The Court of Appeal overturned the first instance judge. Of course, it was through the prism of an assault claim rather than a negligence claim, but it's the same sort of exercise. And the second reference, please, is the decision of the Court of Appeal in Stenning against the Home Office. That's at volume 4, authority 38, paragraph 62 to 63, memory stick 1494. And that was a case in the context of a prison where there was a complaint about the risk assessment that had been made by a prison officer responsible for keeping the inmates safe. And the Court of Appeal there said that absent very good evidence, the courts shouldn't intervene with the assessments made by de facto experts.
Can I ask you, on the question of negligence, the critical, one important criticism that Lady Justice Hallett makes of the judge is his finding that the detective sergeant could have waited.
Yes.
As he was bound to attempt the arrest or risk losing the suspect, who could have decamped at any moment, and the evidence.
Yes.
Now, we know from paragraph 9 of the judge's judgment that the detective sergeant himself said that there was some urgency because of a fear of loss of evidence.
Yes.
But without the drugs that he believed to be in Williams's possession, evidence against Williams would be limited to his own observations of what he believed to be drugs, and without the drugs, that wasn't likely to prove enough for a successful prosecution. Now, the judge rejects that at paragraph 19.
Yes.
And says, in my judgment, they could have waited.
Yes.
And selected a safer or better opportunity.
Yes.
Now, I'm just wondering, was there a basis for his finding in paragraph 19 in the evidence, or was it raised with the detective sergeant in the court?
Oh, well, I'm not sure. I can't help with that. But the criticism made was that the evidence was one way. The officer had given his assessment. He's an officer who might have had limited experience of this particular type of arrest. But for a police officer to say that there's a limited amount of time you can hang around watching a drug dealer because sooner or later they will realise that what's about to happen, in my submission, is evidence which would need some countervailing material before it could be properly dismissed. And Lady Justice Hallett, with all her experience in this field, in my submission, perfectly entitled to say that that's unrealistic. You've got 4 police officers closing in on the offender, who is going to be alert because of what he's got in his possession, and the Court of Appeal, in my submission, cannot be were perfectly entitled to reach the finding they did.
Yes, so are you saying that it wasn't a proper basis for the judge rejecting the detective sergeant's evidence that it was a matter of urgency, or are you saying that or I suppose it's another way of putting it, are you saying that his finding that there was no urgency was one that wasn't reasonably open to him?
Well, I think I'll say both, but ultimately I adopt the approach taken by the Court of Appeal.
We were told in opening, Mr. Johnson, that I hope I got the note right, that the sergeant had accepted that if he'd noticed Mrs. Robinson, he would have, I think the expression was, walked on by.
Yes.
I've been looking for that. Where is it in the recorder's judgment, or is it paragraph 10? There may be something else which justifies it. But if it's paragraph 10, it's not quite that.
No. Well,
I mean, and the inference, presumably, is that there was that moment when they were talking, which you can see in the video if you look at it,
Yes, yes.
almost against a wall.
With their backs to the officers.
And they chose a point when there was actually no one immediately by the group, though this Mrs. Robertson had just passed by. And there were a series of people, one can see it on the stills, who had been going by regularly in both directions.
Exactly that. I mean, the content of the video is entirely unsurprising. It's what you'd expect in a town centre with passers-by pretty regularly, and within the context of that, the very unfortunate, of course, for the appellant, but the police chose an opportunity as was going to be available. Now, of course, I accept that the officer accepted that he didn't notice the appellant, and that may well be because at that precise moment, so having waited for an opportunity when it was relatively clear, his attention, and this is me submission rather than evidence, his attention then, but in my submission, if you watch the video, this is a reasonable approach, was on Mr. Williams, focused on him, and just didn't notice the appellant coming from behind her. Could I just come back to my Lord, I think it's my Lord Reed's point about on which basis, or how I categorise the judge's error, the recorder's error in rejecting the officer's evidence that he couldn't simply wait. That's dealt with in Mr. Justice Arnold's judgment at paragraph 67, and it is both of the reasons that my Lord set out. So I do rely on both of those.
I think the question that Lord Hughes asked about walking by on MS 225, we find it in the Detective Sergeant's written statement in paragraph 14.
225.
Yes, this is the witness statement of the Detective Sergeant, where he says, had it appeared to me that someone was in harm's way,
Yes.
I would have carried on walking by.
That's what's quoted in paragraph 10 of the recorder's judgment,
Yes.
but it isn't the same as if I'd seen this lady, I wouldn't have done what I did.
No, because yes, quite. Yes, and the next sentence, I didn't see Mrs. Robinson, who I believe had just stepped off a bus and walked past Williams. My Lady, my Lords, there are other submissions that we've advanced in our written case. I haven't developed them all orally. They include the comparative law. That was pretty thoroughly looked at in Brooks. You were treated to it again in Michael. I'm not going to go through it orally, but you have plenty of materials in the bundles. And some submissions about the various opportunities Parliament has had to intervene in this area. That's an area that the court is very familiar with grappling with. I'm not going to develop those submissions.
We won't treat you as having abandoned anything that's in your written case just because you don't happen to have mentioned it while on your feet.
That's the point. My Lady...
The normal reassurance we try and give people.
I'm grateful. My Lady, those are our submissions, unless there's anything on which I can assist.
Thank you very much indeed, Mr. Johnson. Mr. Skeld? Mr. Bowne.
My Lords, my Lady, I'm grateful for Mr. Johnson because I took 3 of his minutes and he's given me some back now. Could I hand out the speaking note that Mr. Johnson has seen, albeit he saw it, we handed it to him at 1 o'clock. I'm going to go to the speaking note really just because that's where we've dealt with Proposition 8, which my learned friends responded to orally. But I want first to deal with just a factual point. MS 157. Paragraph 1 of the recorder's judgment. Just below paragraph B, first she became aware of any of the events about which I've been hearing was when she was bundled over by a group of men, one of whom was the person that the police officer were trying to arrest, Mr. Williams, and two, it is fair to say, sturdily built police officers that were trying to restrain him, at least one of which fell on top of her, as did Mr. Williams. She ended up underneath those two heavy men, injured and traumatised. And I'm told, actually, although I haven't seen it, that we got her blouse from the day still, which has apparently still got a great big boot mark on it. I don't know, I could hold it up and show you if you wish, but I've resisted that thus far. Couple of words on the duty, on a central argument that the Michael judgment is based on two principles which apply separately, both the emissions and the Hill rule. Particular interchanges between my learned friend and Lady Hale. We say that contention does not properly address what Michael and Lord Toulson says specifically at 115 to 116, expressly indicating that the police should receive no special treatment. The key question is applying common law principles should there not be a duty. Well, plainly here, here is an example of special treatment being afforded to the police.
Does he actually say they shouldn't have any special treatment, or does he say that the application of the omissions rule, as he calls it, does not involve treating them specially?
Well, he said, as I understand it, that
Those are two different things, aren't they?
well, that there should be no special. There's not an immunity. There's no special treatment.
Well, there clearly is, to some extent, as you agree,
Yeah.
because you accept Hill.
Well, that's true. That's true.
Yes, but what he says at 115 is he looks at the narrower approach to Hill that you pray in aid. That is the one that Lord Phillips spoke of in Brooks, and says that doesn't involve giving special treatment. Yes. He is not saying if there is a wider scope to the Hill doctrine that there isn't special treatment for the police.
Well, I mean, our understanding and analysis of it is that we rely on Lord Phillips expressing it in a narrow sense, paragraph 79.
Yes.
My learned friend went through Michael, and he landed upon, I think it might have been went through Smith and looked particularly at Lord Hope, I think around about paragraph 61. Equally, when he also went through Michael and said, well, look what's happening in Michael. Lord Toulson is looking back at Brooks, he's looking back at Smith. He seems to be agreeing with what the judges are saying. All he is in fact doing is he is cantering through it relatively briefly and not terribly analytically. I don't mean that critically. He's just rehearsing what he's not making he's not giving a judgment on what they were saying the core rule amounted to. He equally, as well as referring to Brooks, he refers to Lord Phillips at, I think, paragraph 63. So we get nothing from that. You can't sort of cherry pick little parts of these cases and say, well, that's why that's narrow. I did spend many hours going through all of this, trying to work out exactly who said why, who went wide and who went narrow, and when did it happen, and at what time did it happen. And you can just get stuck for
Yes, but it did strike me that deciding what the lordships were talking about as the core principle in these cases wasn't entirely clear. The expression is used, for example, in Brooks, I think, by Lord Hope without any definition.
Yep, absolutely, that's absolutely right. And in fact, the Australian...
Sorry, in Bancourt, I think it is, not Brooks.
Yeah, the Australian article I took you to is, and also I think there's an article entitled by Dermot Walsh entitled Policy Fog. All of that material in Bundle 8 goes through that process. And for instance, MS, just at random, MS 2640, there's a heading saying uncertain content. Nobody actually knows what the rule is. So
There's no nobody's drawn our attention to any authority before Hill in which this rule was
No,
raised.
I mean, if you look...
It's a creation of Hill and the subsequent cases. Is that correct?
Yes, I mean, there is some reference back from memory to some very old cases that your ladyship referred to. We referred to them in Michael. They're
Your
the
memory
ones-
is better than mine.
Well, you do lots of cases. There's a case involving Blackburn commissioners or something.
Yes, it's 1968 by common law police
Yeah, the old
officers.
common law principles, which seem to go much wider, which have been used, and I used them in the Michael case to try to say, look, it's all about, I think, the fact that public policy and the courts of the common law have restrained members of the public from picking up arms themselves, protecting themselves, because they rely on the state to protect them. I mean, that was all about assumption of responsibility and the attack that we then made on Hill. So there is old material like that, but I think you're right that the approach, the proximity approach, then the policy approach in Hill was probably the first major. There were other public authority cases which were beginning to use public policy at that stage in the late 80s. But there is the reason that we don't need a panel of 7 here to if you were to find for us and say that it in fact should be restricted as per what we say Lord Toulson and the majority meant, is that you are doing, and here it's perfectly proper for me to refer to Lord Kerr, who at, I think it's, give me a moment, I think it's 171, he says that the public policy in the view of one set of judges 5 years ago, 20 years ago, 30 years ago, doesn't bind another set of judges who may well take a different view. We see that at, sorry, I have so many pieces of paper here. Yeah, paragraph 161, 1776 to 1776H. The policy view of one set of judges doesn't bind another. So if you, the fact that what Mr. Johnson is doing is he is, in terms of the width of the rule, he is looking back at what was said in Smith and Van Cole particularly. He's relying on certain aspects. He's cherry-picking, ignoring other aspects, predominantly paragraph 79, ignoring the fact that defensiveness is now effectively a dead duck, as are most of the other policy concerns that were influential 15, 20 years ago. And what has replaced that, I say, that pretty much that entire construct is a construct that relates to orthodox principles. And the reason that he's doing that is in order to bring rigor, clarity, certainty. So people know, the police know what the law is. In theory, the people know what the law is, although citizens don't go around thinking, oh, how far is the incremental process proceeded with? Can I do X? You know, it's a sort of certainty of law point. At the moment, we have a degree of chaos in this area. And I don't think I'm exaggerating, because that's what all the commentators have said. Mr. Johnson has manfully attempted to, for instance, explain Rigby. In my respectful submission, he has comprehensively failed to explain Rigby. He appears to have referred at one stage to questions of sort of serious fault, sort of high degree of fault, so sort of almost a French approach. He's referred to it by reference to, so high degree of fault, loss of life, injury, that impacts upon proximity, public policy. You look at breach. I mean, just throwing all of these concepts around, and it doesn't provide a vehicle by which you can analyse a case like Rigby and say, well, actually, what was the basis of liability? Well, nobody has done that thus far.
I mean, Lord Keith treated Rigby as a paradigmatic case. It's not nothing odd about it. Yeah, I mean, he says there's no question but a police officer, like anyone else, may be liable in tort to a person who is injured as a direct result of his acts or omissions. Examples, Knightley, Johns, Rigby.
Exactly.
I mean, Mr. Johnson takes issue with you on the issue of causation, and therefore whether this case falls within the ambit of that proposition. But you say it does. And Lord Keith identifies the whole point in Hill as not being to do with that proposition at all, but being whether the question of law, he says, which is opened up by the case, is whether the members of a police force owe a duty of care to members of the public who may suffer injury through the activities of criminals.
Yeah, narrow.
And I mean, Mr. Johnson would argue that that's this case because of the view he takes of causation. You argue that it's not.
Exactly. And Rigby, just like the quote that you have just referred to, my lord, just for your note, it's at page 39, Roman 7 of my speaking note, but I think I've already referred to it and taken you to it. Capital and Counties, Stuart Smith LJ, at 1031H, he looks at Rigby, and he's, I think, really the only judge who has said accurately what we respectfully suggest is the explanation for Rigby, which is piggybacking on Lord Keith, going a little bit further and saying, well, it's not only a positive act case, but it's a positive act case that created a danger.
Yeah.
And that falls in, that slots in properly into an incremental category. So, and the only reason, why have all of these judges gone out of their way to explain Rigby in a different way? They've done it because they have been trying to explain how there can possibly be liability in a case like Rigby, a siege case, an arrest case, a case within the wide core immunity that Mr. Johnson persists on suggesting is the law. And it is, in my respectful submission, absolutely fanciful for him to say that as he does about Michael, that at paragraph 115 of Michael, the judge was not talking in any sense about, I've lost Michael for a moment, hold on.
1-6.
He was not saying, he was not talking about Hill, he was talking about, hang on, he was talking purely about the omissions principle. Well, that can't be right. Oh, sorry, it's paragraph 97. It's under the heading, issue 1 and 2, did the police owe a duty of care to Miss Michael on receiving her 999 call? Now, the whole point of Mr. Johnson and Lord Pannick's was that they didn't owe a duty because of Hill. In fact, I think advisedly, but I think I'm right in saying that the omissions principle didn't even find its way into the written case of the commissioner of South Wales, of the Chief Constable, in the Michael case. There was, in fact, bizarrely, almost no interchange at all between bar and bench on the omissions principle. I think Lord Mance asked me one question about omissions, and I said something probably inaccurate about Gorringe. But there was no discussion about Smith and Littlewood. So when the decision came out, we were sort of pleasantly surprised that there was an explanation, but slightly taken aback that it hadn't really featured in the argument in any sense. So Michael was totally about Hill and, as Milady has said, a full frontal attack on Hill. A few words about what we're saying about reasonable foreseeability. Again, with respect, my learned friend is mischaracterizing what we are saying. We are not saying that there is always a duty not to cause personal injury on the basis that it's reasonably foreseeable. We specifically disavowed that, but he persists in muddying the waters and suggesting that we do. We have restricted it through my second proposition, very carefully thought about the words, restricted it to physical harm, not psychiatric harm. We have given some content to it in terms of source of danger, immediacy, vicinity. We do not argue for a general duty. That brings me quite nice and neatly onto the question of suspects, a question that Lord Mance particularly was interested in asking questions of both of us. Can you have a duty to a suspect? And I think, in fact, Lady Hale to me said, well, can you? And I think I said no. And you said, well, actually, you can, in theory, and there's at least one case, the driving case, that says that you can. I think my primary answer is that, well, first of all, I don't need to go there, but I don't think there is a duty to a suspect. But if there is a duty to a suspect, then there are a range of defences available to the police. Most obviously, and I haven't mentioned this thus far, neither of us have, is the availability of the illegality defence, extirpi causa, which has, of course, been litigated uphill and down dale in about 6 or 7 cases, which you all know about, Patel and Mirza being the most recent, which again is now the subject of another piece of litigation going through, which may or may not reach you in due course, involving a claim that I'm bringing on behalf of a woman who murdered her mother when she was a psychiatric patient in the community, not recalled, terrible tragedy, kills her mum. That's now pending before the Court of Appeal, and that's looking at, again, at Clunis and Gray, and the range of factors approach that was just by a whisker preferred to the certain approach
Well, I think
would
we might
mean
say
that
more than a whisker.
I can't quite remember. There were 9 of you, I think.
Well, it was male, anyway.
Memory. Yeah, well, they're deep waters, which I obviously can't get into now.
I think it would be unwise to get into them. We've got other things to do.
The simple point is that if Williams sued the police when he is in the middle of being arrested as a result of criminality, then I am quite sure if I acted for Williams, as I probably would, and Mr. Johnson acts for the police, as he almost certainly would, then he would raise illegality. And who knows what would come out in the end. But
you're saying it's all up for grabs, that area.
It's all up for grabs still.
Anyway, we don't have it with us at the moment, so...
Yeah, okay, but there is something to think about. Also, Dr. Fairgrieve tells me that I should also urge upon you the concept of justification with a negligence claim. There is an entire book by Mr. Goudkamp, called Tort Law Defences, and an argument about whether you really ever do have a defence in a tort, or just you simply have no duty of care. But there are plenty of answers to the problem that might arise, that if you have a duty to innocent bystander, query whether you have a duty to a suspect. He gave various examples, applying handcuffs, shooting terrorists, suicide bombers. Those are all, again, suspect cases. They are not bystander cases. And I bring in here a sort of Lord Nichols argument. And you see it in Waters. There, I can't give you the references offhand, but you probably know them, and it's familiar territory, that the law has got to accord with to some degree with common sense. The law should not be an ass, frankly. And somewhere in that speaking note, you'll see the Wikipedia entry as to who first referred to law as an ass. And if Mrs. Robinson's claim has real force. And it has real force because, as Lord Nichols has said, I think at paragraph 6, in terms of exceptions, that the law should really reflect common sense. And in this sense, if there is no duty, in our submission, it really will not. And it's not necessary in terms of the rule, for all the reasons I've set out, to deny liability. The Hill rule then becomes disproportionate. The only other thing I think I need to cover... Oh, Criminal Injuries Board, CICA. True, she got £750 after deducting her costs. She was awarded £1,000 and I think got 750. Yeah, so plainly not proper compensation for the injury that she suffered. Reference to Rigby in Desmond at MS 401. There was no explanation by Sir Anthony May as to the basis of Rigby. Calverley, I need to say a couple of words on. Although Mr. Johnson didn't really cover it. Calverley was a case of wrongly pursuing officers for disciplinary processes. Again, it was held that there was no duty of care to a suspect. Lord Bridge found that there was it wasn't reasonably foreseeable that they would suffer psychiatric harm. It wasn't a physical injury case. It was also predominantly, I think, a claim for economic loss, because the officers were reinstated after a considerable time when they lost overtime. So we apply our arguments to explain and distinguish Calverley, and I do it, you'll find it from page 42 onwards of the speaking note. And we say it's not a problem because it's distinguishable from the milestone cases, and it's not as claimed in Mr. Johnson's case, MS 110, an illustration of the general rule. The case does not establish that the general rule covers all positive acts connected to the investigation and the suppression of crime, meaning that there is no duty of care, and neither does it disapprove of limiting the Hill principle. It's simply an example of the principle that no duty is owed by the police in the course of an investigation to a suspect. Well, sorry, that was the claim, and what the judge said was this startling proposition founders on the rocks of elementary principle, 1238B. And then I go on to develop that up to page 46, and I'll just, Mr. Johnson's seen it, and I just read that into my submissions. Just a few words on breach of duty.
Can I just go back to Michael, just to the paragraphs 114 to 115 at MS 440.
Yep.
I mean, is it interesting if we're considering whether this establishes a general principle, a second principle separate from the initials principle, that in fact the cases referred to in 115 are cases of economic loss in the first two, damage to defective foundations or defective foundations in the others, and then physical injury. They're all put together. I mean, the first two are cases of complaints about,
Regular.
in the case of Ewan, complaint that a deposit bank was registered or continued to be registered, but both. And the second one was a complaint that the Savings and Investment Bank, a very famous bank, was licensed or continued to be licensed by the Finance Board of the Isle of Man. So, I mean, they were cases of positive action, and they're all equated with the present situation, the situation in Michael, which is some physical damage.
Well, they were pure economic cases.
I know, but I mean, the fact that they were equated suggests that there may not be quite the sharp distinction you've drawn, and which Perrott, perhaps, Lord Justice Hobhouse, drew.
The explanation may be that they're all cases to do with public law duties, and the proposition is that the public law duty doesn't bear with it a private law duty to avoid causing harm to the members of the public.
Yes.
Whereas in the present case, unlike Hill, where there was a public law duty on the police to investigate the offences and attempt to catch the perpetrator, in the present case, you're dealing with a private law duty in the law of tort not to barge into pedestrians on the street.
Isn't that? Yes.
Yes, my lord, and I think the answer to the public law point is Lord Staines's decision in Gorringe, volume 2, paragraph 15. Sorry, volume 2, tab 15.
Is Gorringe the bank that wasn't removed?
Yeah, that's right, and that's pure. It's a pure omission. And the point that Lord Reid has just made is I think explained at paragraph 3. In this, it is the. I'm reading from H because I'm aware of the time. It is this: in a case founded on a breach of statutory duty, the central question is whether, from the provisions and structure of the statute, an intention can be gathered to create a private law remedy. Yeah. In contradistinction, in a case framed in negligence against the background of a statutory power or duty or power, a basic question is whether the statute excludes a private law remedy. An assimilation of the two inquiries will sometimes produce the wrong result.
I mean, doesn't Lord Hoffman somewhere in that judgment distinguish the example of the NHS consultant who is operating on you, and he owes you a duty of care because he's actually doing something to your body and can injure you. Yeah. So that's a perfectly straightforward tortious duty. It's not dependent in any way on public law considerations.
I mean, the difficulty is then still the assimilation of these other cases as if they were relevant. I mean, they were all cases where it was claimed that there was a duty of care and negligence, and rather than saying, they're all irrelevant because they're cases where...
What he's saying is these are all cases where the law places a duty on a public authority of a protective nature, a statutory duty, I think, in all of those cases, and failure to operate that, omissions in the context of operating that duty don't give rise to private law liability. That's what he's saying in that sentence.
Yes, but why is he deploying it in the context of Michael, is the question I was really putting, which is
deploying it in the context of Hill.
If it goes back, I think it perhaps goes back to paragraph 37 in Michael, where Lord Toulson, explaining Hill, begins the first sentence, or second sentence is Lord Keith recognised that the general law of tort applies as much to the police as to anyone else. Yeah. Examples, Knightley and Rigby. Yeah. Last sentence, but he held that the general duty of the police to enforce the law did not carry with it a private law duty towards members of the public.
I mean, it's...
We've
run out of time.
We've run out of time, but was there anything you wanted to say about breach?
Well, there's a lot I want to say about breach, but I can't. It's all in the document.
It's all in the document.
From page 66 onwards. Sorry, the speaking note.
That's what I assumed you meant by the document.
One that we've just handed up. And I would ask you to read that, and you will then see comprehensively everything we say. There was a point raised about D.C. Willan and the actual evidence. That you see under, I think, point 5 at page 72. I mean, I can read out the first 4 paragraphs, which are important, but there's a little point because you can read them yourself.
Well, rest assured that we shall.
I'm sure you will.
And that's probably a better use of our time than... continuing.
As ever, we are very grateful. Those are my submissions. Thank you.
Well, we're very grateful to everybody. both for the written submissions and for the oral submissions. I feel sure there are plenty of people from whom we haven't heard but who've made a big contribution to the arguments in this case. It is, as I'm sure everybody involved, but particularly Mrs. Robinson understands, a very important and difficult case.
Had a long wait, that's
Yes,
for sure.
she has indeed. And we shall now go away and try and work out what the answer is.
Thank you.
And let you know in the usual fashion.
Thank you very much.
Yeah. Court is now adjourned.